Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. I'm going to give people a second to filter in here. This is Blake Lively's motion to dismiss, which just hit the docket in the Justin Baldoni versus Blake Lively case. We were expecting a few responses today. This is the first one I've seen come up, so I'm sure I'll have my work cut out for me all day today. As always, I will post this document in a link in the description of this video and the comments after the stream, as well as on Twitter, where you can find me at LethalLauren904. Like I said, I'm going to give people just a second to filter in here because I don't want anyone to miss the beginning. So give me just 1 second. Okay, StreamYard hates me right now, so that's why I can't see your comments. Give me 1 sec. Then we'll start reading. Gotta pull you up on my phone. There we go. Oh. Hey guys, how's it going? All right, let's get this started, shall we? So we know Ryan Reynolds had filed his motion to dismiss, separate from Blake Lively, and now this is her motion to dismiss Justin Baldoni's complaint. As you guys remember, the New York Times, Leslie Sloane and Vision PR, they also moved to dismiss Justin's complaint. We have to wait till these things are fully briefed before the judge will rule on them, which means Justin gets to respond to each of these motions to dismiss. Now, he hasn't responded to Ryan's, obviously, because that's brand new. He did respond to the New York Times one and to Sloane's. So the judge will be, I think he said he was going to try to rule on those quickly. So we'll probably see a ruling on the Sloane one before any of the others. But okay, let's see. And as always, guys, I'm not an attorney, so please don't take this as any sort of legal advice, anything that I say. I'm just a layperson sharing my opinion, so we may skim over a little bit of the case law stuff, just because I know the Ask Two lawyers and my friend Omar, the Tilted lawyer, will go over that stuff. All right. Whoa, okay, we're getting off to a crazy start here. The Wayfarer Party's vengeful and rambling lawsuit against Blake Lively is a profound abuse of the legal process that has no place in federal court. I was afraid I didn't unmute myself for a second. The law prohibits weaponizing defamation lawsuits like this one to retaliate against individuals who have filed legal claims or have publicly spoken out about sexual harassment and retaliation. The right to seek legal redress and the right of the press to report on it are sacred principles that are protected by multiple privileges, unless you don't like what they're saying, right? Including the litigation and fair report privileges, which are absolute. Moreover, by choosing to bring their claims under California law, the Wayfarer parties have voluntarily subjected their entire lawsuit to the sexual harassment privilege in the recently enacted California Civil Code Section 47.1, which bars retaliatory lawsuits based on public disclosures of sexual harassment and related allegations, including disclosures to the press. So I don't know if that's exactly how they're making it sound. So basically what Wayfarer is saying is that like Lively and Reynolds and all them were colluding with the New York Times to publish this kind of hit piece on Wayfarer and Justin before the CCRD was even filed. And the CCRD complaint was not, it was not an actual public document. So it's like, how did the New York Times have all that time in advance? So I just want to point that out. Okay. Given all of these protections, the Wayfarer party's chief complaint that Miss Lively and others supposedly conspired with the New York Times is barred as a matter of law. She was legally entitled to file her complaint and disclose it to the public. On top of that, Section 47.1 contains a mandatory fee-shifting provision that will require the Wayfarer parties to pay not only Miss Lively's attorney's fees, but also treble damages and punitive damages, if and when their defamation lawsuit is dismissed. In other words, in an epic self-own, the Wayfarer parties have created more liability for themselves by their malicious efforts to sue Miss Lively into oblivion. Steve Sarwitz may indeed make good on his threat to spend $100 million litigating against Miss Lively, but perhaps not in the way he planned. God. This is, I guess we're not playing by any sort of decorum anymore, huh? All right. Among its many additional incurable defects, the FAC First Amendment complaint does not allege a single element of the defamation or false light claims properly, starting with the failure to allege defamatory statements with specificity, instead lumping all plaintiffs' claims together as an impermissible group pleading. We've heard that like 1,000 times by now, right? Okay. Somebody says this motion to dismiss is standard, honestly. Okay, that's nice, but we're going to cover all the documents like I have been, so. All right. Plus, it's obviously interesting to see the kind of snark that they're writing with. Okay. Brushing aside this obvious problem, the Wayfarer parties have repeatedly asserted in recent filings that their claims against all the consolidated defendants, including Ms. Lively, arise from two principal categories of defamatory statements. The first one is allegations that Mr. Baldoni and Heath engaged in sexual misconduct, and the second is allegations that Wayfarer parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation. Okay. This admission is fatal to their claims. As these two principal categories make clear, the only alleged wrongdoing the FAC attributes to Ms. Lively stems from her speaking up about harassment and retaliation, which is firmly protected by each of the litigation, fair report, and sexual harassment privileges. In any event, the bulk of the Wayfarer party's reputation-based claims are time-barred because the FAC expressly admits that Ms. Lively first published her allegedly defamatory sexual harassment accusations in her 17-point list in November 2023. More than 1 year before the Wayfarer parties initiated this action, and thus outside the 1-year statute of limitations. And as for their menacing $400 million damages claim, the Wayfarer parties do not even try to explain its basis, much less specifically allege their so-called injuries. Yet another of the FAC's insurmountable deficiencies is its utter failure to allege actual malice. For example, that Ms. Lively subjectively did not believe the sexual harassment allegations she raised. Other than many pages of empty bluster, the FAC not only fails to allege actual malice, it pleads just the opposite by demonstrating her good faith beliefs. Among other things, the FAC incorporates by reference a damning text message between Mr. Baldoni and Ms. Nathan, in which both agree that Mr. Lively, I think they mean Ms. Lively, genuinely believes she's right and that all of this is unjust. Okay, but that could be taken out of context, so they could be referring to anything, really. I'll have to take a look at the full context if we have it. In lieu of concrete facts, the FAC resorts to implausible conjecture and conspiracy theories to allege that Ms. Lively falsified her allegations. On the one hand, the Wayfarer parties insist that Ms. Lively is an immensely powerful Hollywood superstar who, along with her influential husband, wielded power to steal creative control over the film, but on the other hand, they claim she was so powerless that the only way she could have any power was by manufacturing sexual harassment allegations almost a year in advance in a Machiavellian long game. So that right there is not, they're not saying that's the only way she could have any power. Obviously, like, she had some power just by bringing like the larger celebrities around because Justin was not really sticking up for himself in that context. And I mean, he was obviously, you know, in a position where there are a lot of more powerful people like Ryan and like Taylor and who were pressuring him to do things Blake's way. So I don't know about that. Okay. Those two concepts contradict each other and therefore cannot coexist. Even if these bizarre theories made sense, which they do not, the FAC offers no plausible facts to support the conclusory assertion that Ms. Lively ever subjectively doubted that any of the misconduct she alleged had occurred as she described it, including in the 17-point list that they signed, the disclosures made in the January 4th meeting, or her eventual legal complaints. Indeed, despite its narrative fury against her, the First Amendment complaint repeatedly and consistently includes facts that demonstrate Ms. Lively's genuine, good faith belief that she was mistreated and her appropriate and private efforts to improve the situation for herself and others. As for the FAC's other claims, it is unclear whether a civil extortion claim exists under California law, but even if it does, the nature of the alleged extortion is so convoluted that it cannot survive. The so-called extortion arises out of the exact same categories of protected speech that fail to support defamation. Ms. Lively's supposed threats to reveal her sexual harassment claims if the Wayfarer parties did not give in to her demands for creative control of the movie, threats which are never specifically identified anywhere in the FAC because they never happened. That's actually not true, but okay. I don't know if we read the same document, but she did try to force them to sign that statement. All right. Moreover, the FAC does not allege what money or property Miss Lively received from the Wayfarer parties for supposedly extorting her way into editing a movie for no additional pay. Indeed, the FAC's self-defeating claim appears to be that Miss Lively bullied her way into doing more work than she was contractually obligated to do. Well, how is that true if you don't sign your fucking contract? What are you obligated to do? Without additional compensation, while Wayfarer profited handsomely from the movie's blockbuster success. Notably, the Wayfarer parties did not pursue any action against Miss Lively for this supposed extortion until after she filed legal claims, which speaks volumes about this lawsuit's purpose. Okay. The FAC also claims that Miss Lively violated the implied covenant of good faith and fair dealing, but cannot identify any term upon which that duty hinges. As with above, this claim seems to be based on Miss Lively doing more than was contractually required, rather than a breach of any obligation. Finally, the Wayfarer parties claim that Miss Lively interfered with the contract, yet are unable to identify the contract, any of its terms, who it was with, or how it was breached. Okay, but you're also talking about a contract. So clearly there's a contract, right? But to my knowledge, she refused to sign her contract for the longest time. So I don't know. That whole thing is confusing to me because I was like, why would anyone start work with someone who wouldn't sign their contracts? I still don't understand that one, guys. But we're going to move on. Okay. In short, nothing in the FAC resembles an actionable legal claim. It is instead a blunt public relations instrument, this again, Jesus, designed to further the Wayfarer party's sinister campaign to bury and destroy Miss Lively for speaking out about sexual harassment and retaliation. The court should dismiss the FAC and, as required by California law, hold further proceedings to calculate an appropriate award of Miss Lively's attorney's fees, treble damages for the harm this meritless lawsuit has inflicted on her, and punitive damages against each of the Wayfarer parties. Gigi says, I think it was the nudity writer she wouldn't sign. No, she wouldn't sign the whole contract, to my knowledge. I don't know. Someone in the chat confirm that for me or deny, whatever. Okay. Now we have the background. Give me one sec, guys. Okay. Sorry about that. Far from suggesting her claims are untrue, the FAC, while quibbling with Miss Lively's characterization of events, is full of admissions that the incidents underlying Miss Lively's sexual harassment claims occurred. As set forth in the FAC, shooting of the film began on May 16th, 2023. Starting on the first day, according to the FAC, each of the following incidents occurred. Okay, and they're saying this is what happened according to Justin's first amended complaint. And I'm sure they're going to distort this in a way that makes it seem obviously unfavorable to them. After the first day, and this is the first point, Mr. Baldoni entered Miss Lively's trailer to voice his concerns that Miss Lively looked unflattering in publicly released photographs. During the meeting, Mr. Baldoni became emotional and told Miss Lively that he thought her appearance was failing to meet audience expectations. At some point in May or June 2023, a simulated nude scene was filmed without an intimacy coordinator present. Okay, but is that even true? I don't know if that's true. I'll have to go back and look at that. So I don't want to say for sure that's absolutely 100% false. However, what I'm saying is I don't think she say she wasn't going to meet with the intimacy coordinator, and then that whole thing became a problem. So that's where that gets confusing. Mr. Baldoni discussed orgasming while having sex with his wife, remarking that those have been some of the most beautiful moments between them. Mr. Baldoni asked Mr. Heath to show Miss Lively, while she was eating lunch, a video of Mr. Heath's wife giving birth at home, part of which Mr. Heath subsequently showed her. Mr. Baldoni improvised while filming romantic scenes, which was consistent with his prior experience of rehearsing or filming scenes multiple times, often with variation, without needing permission. Mr. Heath was present in Miss Lively's hair and makeup trailer while she had body makeup removed, and despite her asking him to turn away while they spoke, he may have made eye contact with her at one point, and later apologized after Miss Lively told him that it had made her feel uncomfortable. Well, that's an appropriate response if you're like, she's like, come on in while I'm, naked or whatever, getting her body makeup removed, and then he accidentally makes eye contact or something. And then she's like, hey, I didn't like that. That made me feel uncomfortable. He says, oh my gosh, I'm so sorry. I mean, what else do you want? It's not like he was staring at her. All right. Mr. Baldoni hired a friend to play the obstetrician in a scene in which Miss Lively's character gives birth, and in which he would be in close proximity to her genitalia. So anybody who was hired for that role would have been in close proximity to her genitalia. It was a fucking birthing scene. I don't understand why they think that's a flex. So yeah, he hired a friend. However, the friend was a very qualified actor, which is they always fail to mention that. Okay, so it's not like he just picked some random friend of his, or like, oh, here's my cousin Ronald or whatever, and is like, he's gonna be your OB. Here, Ronald, take a peek at this vagina. That's not what happened. Okay, let's not pretend that they didn't hire a qualified professional for that role. That really pisses me off. Okay? And then the last point, Mr. Baldoni used the word sexy to describe Miss Lively at least 2 times, including once when Miss Lively was wearing a onesie with a big coat. So is the problem then that she did not look sexy when she was wearing the onesie with the big coat? I mean, most of us wouldn't. No, I'm just kidding. Again, I don't know about that context there. But we saw the words that she used when speaking to him. So if you establish that kind of relationship where you have a rapport with somebody and you're like kind of friendly, I mean, I knew he flew back to California, yes, with her and Ryan, the family. So like, obviously the way she was talking to him, which we've seen in text messages and all that, it's like they had that kind of back and forth where they could say stuff like that, especially when they're talking about sex scenes or they're talking about romantic scenes where they're supposed to be doing like sexy things. I'm sorry, I hate to say that, but it's true. You have to kind of talk about that. You have to be able to talk about that. That's not harassment. Okay. Okay. Mildly Mercurial says, no, the coat thing, he said, it's hot. Well, I mean, that just doesn't advance the narrative here. All right. B, Miss Lively privately raised her sexual harassment concerns to Wayfarer, Mr. Baldoni, Mr. Heath, and Sony. As the FAC describes, following the writer strikes, which had ended by November 9th, Ms. Lively's counsel wrote to Mr. Baldoni and Wayfarer to address how to handle a return to the set of the film. The November 9th email explained that it is no surprise to the film's producer that the experience of shooting the film has been deeply concerning on many levels, and that the complaints of our client and others have been repeatedly conveyed and well documented throughout pre-production and photography. The November 9th, 2023 email emphasized that Ms. Lively at that time was willing to forgo a more formal HR process at that time, as long as the set is safe moving forward, and attached a document with 17 protections that will need to be guaranteed and observed by the film's producers. Many of these protections tracked the precise incidents described in the FAC. For example, point 1 required that an intimacy coordinator be present at all times, but that would also require Blake to meet with her. Okay. Wait, why are we jumping from point 1 to point 3? I guess we're not going over all 17 points here. Okay. Fair enough. Point 3 prohibited spontaneous improvisation of scenes involving physical touching, simulated sex, or nudity, and required the same to be choreographed with an intimacy coordinator. Okay, so that point right there, like that's a fair thing to ask for, absolutely. Sure. But the problem is you refusing to work with the intimacy coordinator and then also making accusations about somebody touching you inappropriately or improvising kissing when you've now been seen on footage biting his lip, which I wish I could unsee for the life of me, but I can't. So, hey, Bruce, what's going on? Bruce says, not again, Cousin Ronald. God, I know. Cousin Ronald's out of control, guys. Okay. Point 5 forbade discussing personal experiences with sex or nudity, including with respect to spouses. That has to go both ways, guys. Point 6 prohibited anyone from entering Miss Lively's trailer while she was in a state of undress for any reason. Okay, so just to clarify, is that even if she invites them in first or tells them to come in first? Because that's something that would need to be specified, I think. But okay, sure. Point 10 established that there would be no retaliation for the requests. Point 16 required that all-day players be hired through talent agencies, not personal connections. And point 17 required an all-hands meeting before production resumed. 122, notwithstanding its reported concerns, Wayfair ultimately found the protections agreeable. So again, they're trying to, and let me finish reading this first, and signed an agreement committing to all of the terms of the protections for return to production on January 19th. So signing that and agreeing to those conditions, it doesn't mean, hey, we're admitting that we did all this weird, creepy stuff. It's not an admission of, hey, I'm kind of a little freak and I fucked up. You know what I mean? That just means like, okay, fine. We agree that none of these things, will happen moving forward. Not that they have happened, but that they still won't happen moving forward. So, and again, I want to move back to this point about all players be hired through talent agencies, not personal connections. The man was an accomplished actor. And also, Blake's sister got to be on set and got to be an extra or something. Like she was, I don't know if she was an extra or if she just had a small part. I can't remember. But Blake's sister was also, through her connection to Blake, let's not pretend, as part of the film. So that's entirely hypocritical. And I really hate that. Okay. On January 4th, the parties attended to the agreed all-hands meeting in the penthouse. Please, in the penthouse. Do they know the trial can't take place in the penthouse? You have to go to that. During which the FAC alleges that Miss Lively read aloud a list of grievances that the Wayfair parties alleged they believed were as troubling as they were fictional. Yeah. Okay. See, out of desperation and fear that their reputations were at risk, Mr. Baldoni and Wayfair decided to go on offense. At some point in the summer of 2024, Mr. Baldoni and Wayfair grew increasingly fearful, desperate, and terrified that Miss Lively would publicly discuss what happened on the set of the film and decided to go on offense, engaging a team to discredit Miss Lively before her previously documented sexual harassment concerns could become public. Among the individuals who Mr. Baldoni engaged for this work were his co-plaintiffs, Jennifer Abel and Melissa Nathan. I'm expecting their response today as well. To the Jones suit, if that's still on the same timeline, but we'll see. One thing at a time, guys. In one text message between the two of them, Miss Nathan explained that they could not write, "We will destroy Miss Lively," because one could only imagine if a document saying all the things he wants ends up in the wrong hands. Miss Nathan wrote, "You know we can bury anyone." Okay. Sorry, I'm just reading this footnote right here. Yeah, this is nothing new. Okay. On August 10th, Ms. Nathan's team reported that they had started to see a shift on social, largely due to Jed and his team's effort to shift the narrative towards shining a spotlight on Blake and Ryan. In one text message, Ms. Nathan states that Mr. Baldoni doesn't realize how lucky he is right now because the whispering in the ear, the sexual connotations, there was just so much circulating the press, including reports of other members feeling uncomfortable. Okay. By August 13th, the FAC alleges that Ms. Lively and Mr. Reynolds were facing an overwhelming tide of negative publicity and that social media had turned against them. Whose fault was that, though? That's the problem. All right. And guys, if you haven't seen it yet, Jed Wallace, who allegedly helped with this secret smear campaign on traceable crap, filed his motion to dismiss last night, and I read over that and his declaration, which was actually pretty funny. So you can always go to the live stream tab and take a look at that if you haven't yet. All right. D. Miss Lively takes legal action concerning the Wayfair party's conduct during and after production of the film, which the Times reports on. On December 20th, Miss Lively filed a complaint with the CCRD. The complaint alleges 10 claims under California law, including sexual harassment, retaliation, failure to prevent harassment and retaliation, aiding and abetting the same, as well as others. The CRD complaint is virtually identical to the initial complaint Miss Lively filed on December 31st. On December 21st, the Times published an article titled "We Can Bury Anyone" inside a Hollywood smear machine, reporting on and drawing heavily from the claims and allegations set forth in the CRD complaint. Okay, again, that CRD complaint, not a public document, so sure. The article is accompanied by a video in which a Times reporter summarizes the article, noting that it was based directly on the CRD complaint. Okay. And then this footnote 8 says the court may take judicial notice of the CRD complaint and separately consider it because it is expressly incorporated by reference into the FAC and is a document integral to it. Okay. Sorry, guys. Okay. The article reports on and, in the Wayfarer Party's words, draws heavily from the CRD complaint. The Wayfarer Party sued the Times in California State Court on December 31st. And then we have E. In response to Ms. Lively's legal complaints, the Wayfarer parties retaliate against Ms. Lively with a meritless counterattack. On January 16th, the Wayfarer parties initiated this separate action against Ms. Lively, her husband Ryan Reynolds, and her publicist, the Sloane parties. 2 weeks later, on January 31st, the Wayfarer parties filed the operative first admitted complaint, adding the Times as a defendant, and attaching a 168-page single-spaced narrative timeline as Exhibit A. The FAC asserts 7 causes of action against Ms. Lively, each based upon her exercise of her legal right to speak out about workplace misconduct. Well, the problem I have with that is that workplace misconduct has to actually occur. You can't just invent it based on your perceptions. Okay. 1, civil extortion. 2, defamation. 3, false light invasion of privacy. 4, breach of implied covenant of good faith and fair dealing. 5, intentional interference with contractual relations. 6, intentional interference with prospective economic advantage. And 7, negligent interference with prospective economic advantage. Okay. The FAC seeks at least $400 million in damages without elaboration or any facts supporting that figure. Okay. Now we're moving on to the legal standard, and this is where we might skim over some of the case law stuff, guys, because I know the lawyers are going to go over that stuff. Give me 1 sec. Okay. In reviewing a motion to dismiss, the court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor. This requirement is inapplicable to legal conclusions. A complaint must offer more than labels and conclusions, or a formulaic recitation of the elements of a cause of action, or naked assertions devoid of a further factual enhancement in order to survive dismissal. Argument. 1. The parties agree that California law applies to all claims against Ms. Lively. The Wayfarer parties assert their claims under the substantive laws of the state of California. Okay. While other parties may dispute that a proper choice of law analysis would permit application of California law to the Wayfarer parties' claims against them, Ms. Lively agrees that California law applies to the claims asserted against her. And the footnote 11 says, under New York law, the choice of law analysis is generally done separately for each claim and defense. Okay. That agreement alone is sufficient to establish choice of law. Even in the absence of such agreement, an interest analysis would also mandate application of California law as the jurisdiction having the greatest interest in the claims asserted against Ms. Lively. Unlike any other party to this action, Ms. Lively was employed by Wayfarer, which is based in California, and Ms. Lively and Wayfarer agreed that all disputes related to Ms. Lively's employment would be governed by California law. In addition, the Wayfarer parties based their claims on statements made by Ms. Lively in a complaint filed with a California state agency to seek relief from a California employer's violations of California law. Okay. Sorry about that. All right. California has an interest in not only ensuring that its employers comply with its laws, but also in protecting Ms. Lively's exercise of her right to speak out about and seek remedies for sexual harassment and retaliation. I really don't like the way they're framing this. I mean, we expected them to, of course, but I don't like the way that they're framing all this because it makes it sound like, you know, it's if people were assuming based on my opinion, right? My opinion, guys, is my opinion. You do not have to think the same. You don't have to believe the same. You just have to be respectful in the comments, please. Assuming based on my opinion that she lied about being sexually harassed, It makes it sound like anyone could just lie about being sexually harassed, and there are no protections for anybody who's on the receiving end of that. Like, you could just destroy anybody with those allegations, and the law protects them. I don't think that makes sense to me, but okay. That's just what they're making it sound like to me as a layperson, right? Okay. California has an interest in not only ensuring its employers comply, but in protecting Ms. Lively's exercise of her right to speak out about sexual harassment and retaliation. Indeed, California provides additional protection from defamation-based suits like this one to those who choose to come forward with their stories about such conduct. Stories being the operative word there. Okay, this is heavily disputed. I think that's ridiculous that that would even be a thing. Surely the lawyers can clear that up when they go over these in their live streams. Okay. California made this interest clear by recently adopting Assembly Bill 933, titled Privileged Communications, Incident of Sexual Assault, Harassment, or Discrimination. Section 47.1 provides a qualified privilege designed to ensure that individuals who experience sexual harassment or retaliation are able to share their experience with the courts, agencies, the press, and others without fear of being sued for doing so. For the foregoing reasons, this court should apply California law to the claims asserted against Ms. Lively. I really don't think that's a fair thing at all. Like, I feel like they should get their day in court if somebody's saying, hey, no, these allegations are wrong. And I know people who, like, you know, hate my point of view, or who are like painting this with a political brush, or saying that all women who don't agree with Blake or agree with this approach are misogynistic. I know they're going to hate this, but, you know, people are always talking about the false reporting issue when it comes to sexual harassment, sexual assault, etc. But when people are falsely accused of things like this, like, they don't want to bring it up to everybody. I wouldn't blame them if they just, like, didn't want a lawsuit and that's why they never brought this up before, right? I wouldn't blame anybody for, if they were falsely accused, having too much shame to say anything to anybody else. You know what I mean? But you don't hear about that, right? Because people are just supposed to automatically believe claims, even when there's evidence against them in this case. That kind of goes both ways, man. Because being accused of something you didn't do, especially when it's something as serious as sexual harassment, that can be a very shameful thing as well. Because even if you know you didn't do it, the people around you who you love and care about, or just people in general who used to be respected colleagues or respected, you know, people that you know, all of a sudden they're looking at you like you're some kind of creep. So yeah, I don't, you know, I hate that. I would really hate that if there was actually a law that said, like, these people can't be, there can't be a fight for justice in these cases where people make false allegations. So, all right. The court should dismiss the FAC's claims against Ms. Lively with prejudice because they fail to state claims upon which relief may be granted. Right. The defamation claim fails because the Wayfarer parties failed to identify specific and unprivileged statements. Okay, one sec. I want to make sure I read this because I can't see it on StreamYard. KKB, thank you for the $20. Hey, Lauren, just now starting the live, so I'm catching up, but wanted to thank you for bringing us the tea. Absolutely, I cover all the court documents. Thank you for listening. Okay, appreciate it. The defamation claim fails as a matter of law. To state a claim, a plaintiff must plead A, a publication that is B, false, C, defamatory, and D, unprivileged, and that E, has a natural tendency to injure or that causes special damage. Not one of these elements is adequately pled. The Wayfarer parties failed to meet basic pleading requirements to identify specific defamatory statements by Ms. Lively. As a preliminary matter, the defamation claims must be dismissed based on the Wayfarer parties' utter failure to plead any allegedly defamatory statements with sufficient specificity. Okay. To survive dismissal, the disparagement set forth in the complaint must be sufficiently close to the actual words proved to acquaint a defendant with what he must defend against. Let's see. Even under liberal federal pleading standards, general allegations of defamatory statements, which do not identify the substance of what was said, are insufficient. This is especially true for libel. Okay. And then they're citing that case here. The general rule of which is that the words constituting an alleged libel must be specifically identified, if not pleaded verbatim. Okay. Even for slander, a plaintiff must plead with sufficient particularity to give notice of these issues and enable defendant to prepare a defense. A defamation claim must be dismissed unless it is specifically identifies the specific words as well as who said them, to whom, and when. Okay. And I think this is part of why they might, do a second amended complaint if allowed, because they want to make those things more clear. But again, that's something the lawyers will get into. All right. As set forth above, the FAC does not assert a single defamatory statement attributable to Ms. Lively, and instead identifies two categories of defamatory statements that are entirely contained within the four corners of the legal complaints. Yet nowhere do the Wayfarer parties explain which of the 8 plaintiffs in this action was allegedly defamed, identify any purportedly defamatory statements made by Ms. Lively, or otherwise identify any false allegation asserted by her that supports their defamation claim, leaving Ms. Lively to guess at what to defend against. You gotta be kidding me. The claim fails for this reason alone. That's like playing stupid. It's like, oh my gosh, what are you talking about? I have no idea what you're talking about. You know what I mean? Like that's no. We're not cool with that. All right. 2, the statute of limitation bars defamation liability premised on statements made before January 17th. Okay. Even if the FAC does sufficiently allege defamatory statements, any statements related to sexual harassment must be dismissed as outside the 1-year statute of limitations. And this is where we get back to like why I read these things on the YouTube in the first place, and why I'm so interested in and like have such a kind of, I don't want to say passion, but just an interest for going over these things and kind of picking apart what's going on. It's because even if like this stuff was dismissed on a technicality, like it was right outside the 1-year statute, something, in my opinion, something wrong happened here. And just because it's outside the statute of limitations doesn't mean it wasn't absolutely abhorrent for somebody to make defamatory or false statements about sexual harassment, to make allegations like that. Like, you might get away with it and again, the lawyers will get to like the merits of that. You might get away with it because of statute of limitations, but in the public eye, in the court of public opinion, that's not going to work. So, okay. To survive a motion to dismiss, the FAC's defamation claims must be premised on statements made on or after January 17th. Here, it is obvious from the face of the complaint that Ms. Lively published the same sexual harassment allegations on which the FAC's defamation claims rest well before January 17th, 2024. The FAC, for example, asserts that Ms. Lively first conveyed her allegations via the 17-point protections for return to production on November 9th, 2023, which was shared with both Wayfarer and Sony, although they admit she had raised some concerns as far back as May 2023. As early as November 2023, the Wayfarer parties believed the document to contain false accusations couched as demands that Mr. Baldoni and Mr. Heath engaged in sexually inappropriate conduct during filming. The FAC goes on to admit that during the January 4th, 2024 all-hands meeting, Ms. Lively read aloud a list of grievances, including those in the protections for return productions as well as others, which again the Wayfarer parties believed were fictional and had either never happened or had been grossly mischaracterized. The FAC thus confirms on its face that Ms. Lively published her sexual harassment allegations to Wayfarer, Mr. Baldoni, Mr. Heath, and others prior to January 17th, 2024. So this, it doesn't matter because it happened too long of a time ago is super gross to me. And I know they're arguing like a legal thing. I understand that they're like trying to do whatever they can to get this dismissed, but like, ew. Seriously, ew. The face of the FAC makes clear that the sexual harassment allegations contained in Ms. Lively's legal complaints, and that those that appear in the Times publications, first appeared in the 17-point protections for return to production and or the list of grievances read aloud on January 4th. Okay. This much the Wayfarer parties cannot dispute, since their theory is that Ms. Lively used those grievances and the 17 points to seed her allegations more than a year before filing her CRD complaint, and they believe these points allegedly established the foundation for Ms. Lively's baseless claims of pervasive sexual harassment in the perfect narrative poison pill. Consequently, this court should dismiss with prejudice the category of defamation claims in the FAC based upon Ms. Lively's sexual harassment allegations. Oh boy. Okay. 3, multiple privileges bar the defamation claim. One second. All right. The defamation claim must also be dismissed because the FAC is missing a key element of the Wayfarer party's affirmative pleading burden. Specifically, the FAC fails to assert that Ms. Lively's allegedly defamatory conduct was unprivileged. It is entirely appropriate to adjudicate privilege on a motion to dismiss and is more than warranted here. Shockingly, all of the Wayfarer parties have alleged defamation claims against Ms. Lively. Not that shocking. Yet the FAC does not attempt to explain how any of Ms. Lively's statements were unprivileged vis-a-vis any one of the plaintiffs, such as Mr. Sarowitz or Wayfarer Studios. To the contrary, the FAC's allegation established that all of Ms. Lively's alleged conduct was privileged. Okay. 2 separate and absolute privileges bar the defamation claim. Give me just a second. I need to check something real quick. Sorry, guys. Okay. The FAC accuses Ms. Lively of leaking the CRD complaint to the Times, which, even if it was true, is protected by the fair report privilege, a definitive and separate bar to the defamation claim. The fair report privilege shields liability arising from a communication to a public journal of A, a judicial, B, legislative, or C, other public official proceeding, or D, of anything said in the course thereof. This privilege is absolute and construed broadly. Although the fair report privilege is typically invoked by news media defendants, it also protects those who communicate information to the media, including those who deliver copies of official documents to a news outlet. So, again, this issue here is that they were apparently working with the news outlet long before there was any official document regarding the CRD complaint. So, indeed, the legislature amended Section 47, abrogating a prior ruling that an attorney's transmittal of a copy of a pleading to a newspaper was not protected by the fair report privilege. That amendment created the bridge between the litigation privilege, which covered statements made in judicial proceedings, and the fair report privilege, which covered media reports of judicial proceedings, to protect a third party who communicates this already privileged material to the press. Thus, fair and true communications to the news media about allegations in a complaint are covered by the privilege. But again, it wasn't about allegations in a complaint. They started working with them long before there was a complaint. So, all right. Litigation privilege. Ms. Lively's alleged statements wholly contained within the legal complaints are further absolutely protected by the litigation privilege, which protects publications in any legislative, judicial, or other official proceeding authorized by law, including actions involving administrative agencies like the CRD. Critically, this privilege attaches even before official proceedings are initiated, where a good faith and serious contemplation of litigation exists. A pre-litigation communication is privileged only when it relates to litigation that is contemplated in good faith. Well, then there you go. And under serious consideration. I'm going to withhold judgment on this, on what I think about this, because, like I said, I want to listen to the lawyers go over that one. The litigation privilege is designed to afford litigants and witnesses to the utmost freedom of access to the courts without fear of retribution through subsequent tort actions. To that end, this privilege is absolute in nature, applying to all publications irrespective of their maliciousness. Here, there is no question the privilege applies to both the CRD complaint and the SDNY complaint. Ms. Lively submitted the CRD complaint to the state agency charged with investigating and rectifying harassment and retaliation, as she is legally required to do, which clearly constitutes a publication in the course of a judicial proceeding. The Wayfarer parties assert, based solely on their purported belief that Ms. Lively never intended to file her CRD complaint in federal court, a prediction that is legally irrelevant, and that was disproven when Ms. Lively did just that. More importantly, the privilege protects Ms. Lively's administrative complaint regardless of her intent to initiate additional subsequent civil litigation. California law protects the bridge between the privileges, whereas here, the legal complaints and the Times publications are absolutely privileged. It would defeat the purpose of Section 47 to punish the transmittal of the privileged pleadings to the press. Okay. Applying Section 47 to communications with the press regarding allegations asserted in a proposed amended complaint made before the court granted leave to file such complaint. That same outcome is warranted here. It would be anomalous to hold that a litigant is privileged to make a publication necessary to bring an action, but that he can be sued for defamation if he lets anyone know that he has brought it. The Wayfarer parties attempt to avoid these absolute privileges by speculating that Ms. Lively delivered to and discussed her CRD complaint with the Times before filing it. Okay, sure. How else would they have gone through thousands of pages of text messages? But even if true, that would not constitute a waiver of Ms. Lively's privileges. As explained in Abraham, such a holding would defeat the purpose of the privileges under Section 47. This is especially true where, as here, the FAC concedes that the Times reportedly only after the CRD complaint was filed and reported only on matters within the four corners of the filed CRD complaint, allegedly lifting it nearly verbatim. Okay, 2, California's sexual harassment privilege immunizes Ms. Lively from liability for defamation-related claims. Ms. Lively's statements about the sexual harassment she experienced on set and the subsequent retaliation campaign waged against her, whether made in legal filings to the press or to any other third party before or after she filed the CRD complaint, fall squarely within California's statutory sexual harassment privilege. That privilege provides that communications made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination are privileged under Section 47. The without malice portion of that is absolutely disputed, but okay. Let's see. Section 47.1 also contains a mandatory fee-shifting provision for prevailing parties, which entitles individuals who speak out, like Ms. Lively, to their reasonable attorney's fees and costs for successfully defending themselves in the litigation, plus treble damages for any harm caused to them by the defamation action against them, in addition to punitive damages available under Section 3294 or any other relief otherwise permitted by law. Thank you, mods, for being here, by the way. California enacted Section 47.1 to clarify and codify existing law in direct response to repeated attacks upon individuals who report sexual harassment and to provide a strong remedy to disincentivize retaliatory litigation. Curb a pervasive culture of sexual assault and harassment and provide significant remedies for successful defendants in defamation claims. And that's all well and noble when the person is telling the truth. Members of the California legislature explained that Section 47.1 was necessary because, while positive, the Me Too movement also unveiled a predatory culture that persists across all sectors of employment and society, in which many victims have been served with defamation lawsuits. The legislator went on to describe these retaliatory suits as a weapon to threaten, silence, intimidate, and dissuade their accusers. Okay, I'm going to say this again. People do lie. People do make false accusations, okay? And the victims of those false allegations who have their lives ruined, they matter too. Like, we always act like these people don't matter. They matter too. To curb this weaponization of the legal system, Section 47.1 provides immunity against claims seeking to hold individuals liable for speaking out about their experiences with sexual harassment and related claims, including retaliation and aiding and abetting, whether in a legal proceeding, to the press, or otherwise. Under Section 47.1, a covered communication is defined as any factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication, including 1, an act of sexual harassment by a director or producer under Civil Code Section 51.9, and 2, an act of workplace harassment or discrimination, failure to prevent an act of workplace harassment or discrimination, aiding, abetting, inciting, compelling, or coercing an act of workplace harassment or discrimination, or an act of retaliation against a person for reporting or opposing workplace harassment or discrimination. Okay. To be protected by the sexual harassment privilege, the speaker need only have or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. In other words, the sexual harassment privilege attaches regardless of whether a complaint is ever filed and no matter who the communication is published to, as explained by California's legislature. So the way this is being presented right now, this is what I'm saying, I'm like looking forward to lawyers explaining it, because this is extremely concerning to me. Like, anybody could just abuse these things to like punish someone for not giving them what they want, or for saying something they don't like, or for misperceiving a situation. Like, it, oh God, this is a disaster if it's actually that simple, but I don't think it is. The protections would apply to individuals who, after relaying any factual statement, whether in the form of a formal complaint or a statement outside a formal proceeding, such as to a media outlet, are sued for defamation. Indeed, the statute was enacted in large part to address defamation claims filed against harassment victims based upon statements made to the press. Section 47.1 plainly applies to each of the Wayfarer parties' defamation claims against Ms. Lively. To begin, the FAC's allegations establish that the Wayfarer parties' defamation claims rest on communications made by Ms. Lively regarding an incident of sexual harassment. In fact, the Wayfarer parties have already conceded as much in their oppositions. They confirm their claims arise from Ms. Lively's sexual harassment allegations against Mr. Baldoni and Mr. Heath, and allegations of a retaliatory smear campaign against all the Wayfarer parties after she reported the misconduct. Each and every factual statement that the FAC identifies as false or defamatory relates to an incident of sexual assault, harassment, or discrimination experienced by Ms. Lively at the hands of her director, producer, or employers. Further, the FAC fails to identify any particular statement within the CRD that Ms. Lively made with malice, about any of the individual plaintiffs, let alone all of them. And for this separate reason, Section 47.1 requires dismissal. For the FAC fails to allege actual malice, because Mr. Baldoni is a public figure and Ms. Lively's allegations of sexual harassment concern matters of public interest, whether privileged or not, the constitutional standard requires that the Wayfarer parties must plausibly allege that Ms. Lively acted with actual malice, such that she had serious doubts as to the truth of her publication. Likewise, to overcome the privilege conferred under Section 47.1, actual malice must be pled. Far from pleading actual malice, the FAC does the opposite. It confirms that Ms. Lively reported her sexual harassment allegations based upon incidents that the FAC acknowledges took place, and that she genuinely believed her allegations were true. So incidents that the FAC acknowledges took place, it sounds like they're saying that they acknowledged all of her, like the stuff that she alleged had happened. No, they do acknowledge that she, came at them with this list and was like, sign it or else. But that's not, again, they're making it sound a lot different than it is. These admissions are fatal to the Wayfarer party's defamation claims. Okay. Mr. Baldoni is a public figure, and Ms. Lively's sexual harassment allegations are a matter of public interest. The Wayfarer parties concede that Mr. Baldoni is a public figure, subject to the actual malice standard. Similarly, with respect to matters of public concern, the Wayfarer parties acknowledge that the two principal categories of purported defamatory statements center on allegations of sexual misconduct and retaliation aimed towards Ms. Lively, issues that constitute matters of public interest. Okay. And they're citing a case here that says, publicly accusing individuals of rape and sexual assault is unquestionably controversial, but the controversy itself serves to demonstrate that this is a matter of public interest and debate. Whereas here, the defamation plaintiffs are public figures, and the categories of alleged statements involve matters of public interest, they must plead actual malice in order to state a claim for defamation. Defamatory statements regarding matters of public concern are actionable only if the plaintiff pleads and proves that the defendant acted with constitutional actual malice. The actual malice standard is focused on the subjective attitude of the publisher and therefore requires the FAC to plead facts demonstrating that Ms. Lively's statements were made with knowledge that it was false or with reckless disregard of whether it was false or not. It is well established that satisfying the actual malice standard requires more than bald recitation of the words malicious or maliciously. Okay. And the standard for sexual harassment requires more than bald recitations of the words, never mind. Nor is it sufficient to assert that a defendant knew the statements were false or had serious doubts about the truth of the statements. The conclusory boilerplate allegation that defendant acted maliciously and oppressively and in conscious disregard of plaintiff's rights is insufficient to state a cause of action. Okay. The Wayfarer parties failed to allege non-conclusory facts establishing that Ms. Lively doubted the truth of her allegations. The FAC utterly fails to satisfy the actual malice standard. Here, the FAC alleges generally that the CRD complaint's allegations of sexual harassment and retaliation are false. And they cite a bunch of paragraphs from there. The falsehoods identified by the Wayfarer parties, however, center on hair-splitting Ms. Lively's recounting of specific incidents within her legal complaints, or, worse, attempt to justify the Wayfarer parties' behavior, essentially asserting that Ms. Lively asked for it. Really. There's a footnote there, and they're citing these paragraphs. It's not that she asked for it, it's that it didn't happen. Consequently, the FAC does nothing more than describe the exact same incidents from the Wayfarer parties' points of view. Whatever relevance this both sides approach may have out of court, here it only highlights the FAC's total failure to allege that Ms. Lively ever doubted the truth of her own allegations. At best, the FAC asserts that Ms. Lively published the alleged statements either to save her own reputation or as part of a power grab. They allege that she needed a scapegoat to blame for her missteps in promoting the film. They claim she was driven by overweening ambition and a need for control. They assert she wanted to match her star husband or boost her own brand and business ventures. And they state she was determined to extract creative control and to steal the film, or take over the production of the sequel, It Starts With Us. But as described above, none of this actually alleges that Ms. Lively fabricated the sexual harassment allegations or insinuations and the protections for return to production, particularly given that so many of those insinuations directly tracked actual incidents that the FAC concedes occurred. Even taking the above as true, the FAC does not plausibly allege that Ms. Lively actively disbelieved any of the allegations set forth in her verified CRD complaint. The FAC also offers no plausible basis on which to infer that Ms. Lively, which the FAC asserts is one of the most powerful stars in the world, would, over a period of years, 1. Knowingly fabricate sexual harassment claims, 2. Repeatedly report her concerns to her superiors, 3. Negotiate contractual protections to address her concerns, 4. File complaints with state and federal government agencies, and 5. Then years later initiate this litigation, further exposing herself to public comment and ridicule, all to simply have the kind creative control she presumably could have obtained simply by being the powerful star of the film. Jesus. All right. Instead, the FAC is replete with admissions confirming the truth of Ms. Lively's allegation. The FAC admits that misconduct on set did occur and that the Wayfarer parties even apologized for their misconduct. The FAC admits that Ms. Lively repeatedly raised concerns during production about the exact misconduct described in the CRD complaint and the Times publication. Most damning of all, the FAC references a text message between Mr. Baldoni and Ms. Neidigh in which both agree that Ms. Lively, they said Mr. Lively again, which is hilarious. Ms. Lively genuinely believes she's right and that all of this is unjust. And they could be referring to anything. She's right about what exactly? I don't see anything specific there. For the same reasons, the FAC also fails to plead malice sufficiently to overcome application of the sexual harassment privilege. Although neither Section 47 nor 47.1 define malice, courts rely upon Section 48A's definition of actual malice as the governing standard. Under this section, actual malice is defined as a state of mind arising from hatred or ill will towards the plaintiff. However, the section further clarifies that a good faith belief on the part of the defendant in the truth of the libelous publication or broadcast at the time it is published or broadcast shall not constitute actual malice. The Wayfarer party's own admissions, therefore, demonstrate the absence of actual malice. Okay. All other causes of action arising from the same injurious falsehoods must be dismissed. Based on the above, all other causes of action, whether labeled defamation or not, similarly fail. Okay. The Wayfarer parties cannot artfully plead around the First Amendment by dressing up a defamation claim as extortion, breach of the implied covenant of good faith and fair dealing, or any other tort. Okay. Each of the following claims fail for this reason. We have B, the false light claim must be dismissed as duplicative of defamation. The false light claim must be dismissed. In sum, this claim rests on the same alleged falsehoods, the statements within the legal complaints and the Times publications as the defamation claim, and is therefore duplicative. Okay. C, there is no clear private right to sue for civil extortion, and even so, the Wayfarer parties failed to allege extortionate conduct. The Wayfarer parties' claim for civil extortion likewise fails. It appears to be premised upon the implausible theory that Miss Lively was so desperate to seize creative control and to take over production of the film that, despite her power and influence in Hollywood, she manufactured claims of sexual harassment. So they call it desperation here. Like, she would have to be so desperate. Why would she be so desperate? Because she's clearly she's like that powerful actress or whatever they described her as. No, I don't think it's desperation at all. I think it's something much more sinister than that. But okay. In doing so, the FAC alleges that Miss Lively delivered the Wayfarer parties some unidentified ultimatum unless they conceded to her demands. Yet the FAC does not identify a single threat consistent with this theory and, instead, demonstrates that Mr. Baldoni invited Miss Lively into the creative process and to collaborate with him and showered her with praise and compliments for her efforts. As a legal matter, although the Wayfarer parties have admitted that their civil extortion claim is based on California's criminal extortion statute, they cite no California state court case holding that California's criminal prohibition on extortion authorizes private civil claims. Okay. A small handful of California federal courts have divided over whether California recognizes a civil cause of action for extortion. But California state courts have recognized civil extortion only where a cause of action is accompanied by the threat of prosecution made with a knowledge of the falsity of the claim. As more recent state and federal decisions have recognized, Furman is the only California state court case to squarely confront the availability of a civil extortion claim. Okay. And again, we're going to skim over some of the case law stuff because I know the lawyers are going to be going over that soon. Regardless of whether governed by common law or Section 518 of the Penal Code, the FAC does not even attempt to allege the basic elements of extortion, much less with the particularity required by Federal Rules of Civil Procedure 9b. Nowhere does the FAC allege that Miss Lively obtained any money or property from the Wayfarer parties, much less through a wrongful threat of criminal or civil prosecution made with knowledge of the falsity of the claim. The crux of the Wayfarer parties' extortion claim rests on the theory that Miss Lively made extortionate threats to go public with her baseless claims of sexual harassment. This theory fails for several reasons. First, it relies entirely upon the same injurious falsehoods as defamation. Second, because this theory is based upon Miss Lively's workplace sexual harassment complaints and litigation arising from the same is not actionable as a matter of law. Finally, nowhere in the FAC do the Wayfarer parties actually allege that Miss Lively threatened to pursue litigation against them based on their misconduct or demanded any money or property in connection with such a threat. For each of these reasons, this theory fails. Far from pleading facts demonstrating any improper threats made by Miss Lively, the FAC confirms the opposite. Before and throughout production, Mr. Baldoni and Miss Lively worked collaboratively on the film, and Mr. Baldoni effusively praised her for her efforts. And the idea that the Wayfarer parties were somehow induced by any wrongful conduct is further contradicted by their own evidence, in which they openly admit that they were not literally forced to acquiesce to Miss Lively's purported demands. Stripping the FAC of its conclusory allegations and threadbare recitals lays bare that nothing Miss Lively allegedly did falls within the exceedingly narrow concept of extortion. We're getting close to the end here, guys. No worries. Okay. As for the acquisition of property or other consideration, the FAC does not allege that Miss Lively obtained any property based upon her purported wrongful use of force or fear. This was not a drafting oversight. It is undisputed that property was not acquired and money was not paid. On the contrary, the FAC makes clear that the Wayfarer parties retain their rights to their film, a project they had financed, produced, and owned. This in turn dooms any attempt to satisfy the second prong for extortion, which requires not only the deprivation but also the acquisition of property. At best, the FAC rests on the theory that the Wayfarer parties' editing and movie production rights were hampered, not lost. That, however, is not enough and torpedoes any claim of extortion. Finally, regardless of the nature of the Wayfarer party's extortion claim, they have not alleged any damages in connection with the claim, whether the recovery of money purportedly extorted or any damages approximately caused, to the extent California courts have recognized a civil extortion claim. Actual damage are an essential element of the claim. The FAC alleges no such damages, much less with particularity. Hold on. Okay. D, the breach of covenant claim must be dismissed based on the failure to satisfy basic pleading requirements. The FAC fails to plead the essential elements of breach of the implied covenant claim. Under California law, a plaintiff must allege 1, the existence of some specific contractual obligation, and 2, interference with plaintiff's performance of the contract or failure to cooperate with the plaintiff. Here, the FAC argues that Ms. Lively prevented the Wayfarer parties from receiving the benefits contemplated by her actor agreement, allegedly depriving them of the opportunity to produce, edit, and market the film. The FAC, however, does not identify a specific contractual provision that was frustrated, and does not plausibly allege that Ms. Lively interfered with the actor agreement, nor could it, given Ms. Lively completed her performance in the film, which was released as the parties contemplated, to great commercial success. Indeed, the FAC does not even claim that the Wayfarer parties had an exclusive contractual right to creative control over the film, or to produce, edit, and market the film free from creative contribution by Ms. Lively, which Mr. Baldoni openly invited. God, you guys suck. Nor does the FAC allege that Ms. Lively was contractually prohibited from having any creative control over any aspect of the film, the only conduct alleged to constitute a breach of the implied covenant. The Wayfarer party's grievance seems to be that Ms. Lively volunteered to do more than they wanted her to do. Yeah, just by force, which is plainly not a breach. Moreover, as with the remaining claims, the FAC utterly fails to allege either how the Wayfarer parties were damaged or what, if any, damages they incurred. E, the Wayfarer parties failed to allege that Ms. Lively wrongfully interfered with any contract or economic relationship. Good Lord. Sorry, there's more. Okay, good. Let me just... Sorry, something else was filed while we were reading this. Okay. To state a claim for intentional interference with contract, they have to allege 1, a valid contract, 2, the defendant's knowledge of the contract, 3, defendant's intentional acts designed to breach the contract, 4, actual breach or disruption of the contract, and 5, resulting damage. Okay. Because a claim for tortious interference requires a showing of breach or disruption, contracts that are terminable at will generally cannot provide the basis for a claim. Okay. The FAC fails to meet these requirements. The sole contract alleged in the FAC for this claim is a contract between the Wayfarer parties. But the FAC does not allege any details about the contract, including who the parties are to the contract or what the material contractual terms are. Worse yet, the FAC does not even allege a single allegation that the WME contract was actually breached or disrupted, much less a description of when, how, or what contractual term was allegedly violated or disrupted, and somehow damaged the Wayfarer parties. Somehow. All right. Instead, the Wayfarer parties conclude that Ms. Lively, in some unknown way, and Mr. Reynolds prevented performance of the contract or made performance more expensive or difficult, and upon information and belief made threats and or demands to induce WME to cease performing under its contract. God, you know you're full of shit. They're going to have to depose Mr. Emanuel. Missing, however, are well-pled allegations that specifically identify any actions taken by Ms. Lively demonstrating how she purportedly prevented performance. The only specific allegations tied to the alleged breakdown of the WME relationship is Mr. Reynolds' alleged suggestion that the agency was working with a sexual predator. no biggie. And at a later date demanded the agent drop Baldoni. Okay, but these comments cannot support a tortious interference claim as to Ms. Lively, for the reasons explained in Mr. Reynolds' motion. The FAC fails to adequately allege that Ms. Lively interfered with any economic relationship through an independently wrongful act. Absent interference with a specific contract, the FAC must satisfy the more stringent requirements for a claim of intentional interference with prospective economic advantage. It does not. Such a claim requires a plaintiff to allege 1. A specific economic relationship with a third party with a probability of future economic benefit. 2. The defendant's knowledge of the relationship. 3. Defendant's intentional and independently wrongful acts to disrupt the relationship. I'm not sure what's going on here. You guys are talking about back fat in the comments? Okay. All right. 4. Actual disruption of the relationship. And 5. Resulting economic harm. Instead, a plaintiff must plead conduct prescribed by some constitutional, statutory, regulatory, common law, or other determinable legal standard. Once again, the FAC alleges only one economic relationship for this claim, that between the Wayfarer parties and WME, without any additional details as to the actual parties to that relationship, what it entailed, the future economic benefit it conferred, or how or when it was actually disrupted. Beyond these omissions, the FAC does not even attempt to allege that Ms. Lively or anyone else engaged in illegal or independently tortious conduct, as is required to survive a motion to dismiss. The claim therefore fails. 3. The FAC fails to state a claim for negligent interference. Okay, this claim must be dismissed because, in addition to the defects common to the others, this claim is cognizable only when where the defendant owes the plaintiff a pre-existing duty of care. They allege no such duty here. 4. The Wayfarer parties have not even attempted to explain or quantify their alleged $400 million harm. Finally, regardless of which interference claim the Wayfarer parties pursue, each one requires actual quantifiable damages, which the Wayfarer parties have failed to adequately allege. Okay. The FAC repeatedly asserts that the Wayfarer parties were harmed and prays for an award of at least $400 million. But it does not explain how or how much or any of the Wayfarer parties were in fact damaged. The FAC does not allege, for example, that any Wayfarer party has lost specific creative projects, profits, contracts, or suffered any other quantifiable damage as a result of the supposed interference of the WME relationship, which is fatal to each of the tortious interference claims. The FAC muses about a conspiracy, but fails to plead the basic elements. The FAC falls woefully short of adequately pleading the existence of a conspiracy amongst the Lively parties, which requires allegations demonstrating 1. The formation and operation of the conspiracy, 2. Wrongful conduct and furtherance of the conspiracy, and 3. Damages arising from the wrongful conduct. Okay. There are no facts alleged. None. Why do you have to say it like that? Okay. There are no facts alleged. None. Sorry. I did not mean to move that. I'm gonna go back now. That's what I get for being dramatic. That plausibly demonstrate that Ms. Lively and the Lively parties had some meeting of the minds to commit wrongful acts intended to harm the Wayfarer parties. It never happened. Realizing this, the FAC only alleges, on information and belief, that Ms. Jones approached Ms. Lively with an appealing offer to purportedly destroy the Wayfarer parties. That seems almost certainly like what happened, But okay. This, however, does not come remotely close to satisfying Twombly's plausibility requirement. Well, it satisfies my requirement. I think that's shitty behavior. Okay. It says, they're quoting Twombly here, or paraphrasing, declining to accept allegations of conspiracy that were made upon information and belief absent supporting factual allegations. That aside, Ms. Lively cannot share liability with any other Lively party under a civil conspiracy theory because the FAC fails to adequately plead an underlying tort. Okay. Because each of the underlying claims fail as a matter of law, so too must the FAC's civil conspiracy theory. Ms. Lively is entitled to attorney's fees, treble damages, and punitive damages. As a prevailing party, Ms. Lively is entitled to her attorney's fees and damages under Section 47.1, which provides a prevailing defendant shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves, plus treble damages for any harm caused to them by the defamation action against them, in addition to punitive damages available under Section 3294 or any other relief otherwise permitted by law. For the reasons discussed above, the Wayfarer party's defamation claim fails as a matter of law. Having successfully defended these claims, Ms. Lively is a prevailing party under the statute and is entitled to her reasonable attorney's fees and costs, for which Ms. Lively will separately file a motion to recover in accordance with Section 47.1. Separate and apart from her costs and attorney's fees, Ms. Lively is entitled to treble and punitive damages to compensate her for the reputational and emotional harm she has suffered as a result of the Wayfarer party's meritless and retaliatory lawsuit against her. Interesting. Emotional harm. Are we saying there were hurt feelings involved? Huh. Well, somebody should comfort her because her husband won't. Conclusion. The court should dismiss all claims against Ms. Lively with prejudice, deny leave to amend, and award Ms. Lively all relief sought. Oof, finally got to the end of that. All right, hold on. This is the thing that was... What the hell is this? Oh my god. Oh, I hate you guys. Hang on. Please tell me this is not real. All right. So this was filed as well. It's a declaration of Ezra Hudson, the attorney, in support of consolidated defendant Blake Lively's motion to dismiss. There's 146 pages here, and I really hope that not all of this is like new stuff I need to go through, because I need a break. All right. That's a motion to dismiss. Give me one sec, guys. Okay. Exhibit 1. Legislative history report and analysis. Okay. Who's that? Oh, guys, let me just skim through this real quick. I don't think this is something that I need to be reading, but I just want to make sure. Yeah, this is not a for me type of document from what I can tell, but we're still going to skim through. Hang on. Please stand by and listen to my mouse scroll thing. Okay. Yeah, this is like all legal stuff that I will leave to the experts, I think. I don't know if there's like an exhibit 2 or if it's just exhibit 1. Yeah, none of this is for me. Thank God, because there's like, that's 100 and something more pages. I'm so tired. I'm sure I'm going to have other streams to do today. Hang on, let me make sure. Let me make sure I'm not missing anything else before we go, because like I said, these responses are due today, and hers is probably not going to be the only one filed. If it is, that would be a problem, I think, for somebody. Okay, I'm marked safe from any new documents being filed since, you know, we came on the stream. Let's see, who do we got here? Who's on right now? Man, where are, like, what is going on here? Okay. All right, I know what we're going to do. I am going to send you guys to, it looks like somebody's talking about Diddy here. in this case. Yeah, we'll do that. I'm gonna send you over to these guys. I don't really know this person, so if it's you know, you don't have to watch if you don't want to, but I'm gonna redirect you to another stream. Please send them some love. Say it's from Court of Random Opinion, and I will see you guys when the next filing hits. Which who knows? It could be like 10 minutes. It could be several hours. But you know, I'll be around. So remember that Justin has to file a response to Blake's complaint, as well as Jennifer Abel will need to respond to Stephanie Jones' complaint. So I'm going to have a long and busy day ahead of me. Luckily, I'm not working a full day today. So we're all good there. But I do have to do a couple things in between. So I will see you guys very soon, I'm sure. Don't forget to hit the like button for me, and I appreciate it. Also, I forgot to set the setting on StreamYard to public, so that's why I couldn't see your chats in StreamYard, which means any super chats that you guys sent me, if I didn't see it as it was coming up on the chat screen, I missed it. But I'll be able to look back and see them, and I wish I had a way to say thank you to everybody who sent one. I think I got the one that I saw. So, all right, thanks everybody. I appreciate you, and I'll see you soon. Very, very soon.